Okay, here's a riddle for you. How can a single country have three completely different sets of laws for the very same forest? Well, in Malaysia, that's not a riddle at all, it's just reality. And this whole tangled system really makes you wonder, who really controls Malaysia's forests? I mean, who has the final say? To get to the bottom of this, we're going to have to unpack not one, not two, but three competing rule books that are all trying to govern this incredibly vital ecosystem. So, our journey starts right at the top with the country's foundational document, the federal constitution. And right away, you see it creates this really fundamental and honestly kind of tense split in power. And this is the crucial split right here. You've got the federal government, in the capital, and they can set big national policies, they can sign international climate deals, all that stuff. But the state governments, they have the real power on the ground. They have absolute control over the land and the forests. They're the ones issuing logging licenses. And this is the key part. They get to collect all the money from it. And yeah, that really is the heart of the matter. For the individual states, these forests aren't just, beautiful ecosystems. They are a massive source of revenue. A piggy bank, basically. The money they get from timber, it funds their state budgets. And that creates this incredibly powerful economic incentive that pretty much drives every single decision made on the ground. So what happens when you give all this control to 13 different states? Well, you definitely don't get one nice, neat system. You get three. That constitutional split we just talked about, it's basically fractured the whole legal framework into three totally distinct rulebooks. And just look at how different they are. Over in Peninsular Malaysia, they try to have a uniform system with one main law, but then you hop over to Borneo and it's a whole other world. You've got Sabah, which has these huge, 100-year-long corporate licenses. And then there's Sarawak, which is all about super strict state enforcement and is even getting into new things like carbon licensing. It's wild. Three regions, three completely different ways of thinking. Okay, so when you've got resources this valuable, you can bet that enforcement becomes a massive deal. I mean, it's one thing to have rule books, but you need referees on the field to make sure people are actually playing by the rules, whichever set of rules that might be. And we're not just talking about one group here. This is a real team effort. You've got the state forestry departments, the police, and even the Malaysian Anti-Corruption Commission, the MACC. They often work together in these big multi-agency task forces, and they have some serious power. They can arrest people without a warrant, they can search properties, and they can seize everything, from a single chainsaw all the way up to a fleet of bulldozers. They have to take on these organized crime syndicates. But here's the thing. For a long, long time, the penalties were, well, they were basically just a cost of doing business. Get this, before 2022, the maximum fine for a major illegal logging offense in Peninsula Malaysia was about $500,000 ringgit. Now, for a criminal syndicate pulling in millions and millions of dollars, that's not even a slap on the wrist. It's barely a speed bump. And then, boom. In 2022, a new amendment comes in and jacks up that fine by 10 times. We're talking a new maximum of 5 million ringgit. Now that sends a message. It's a signal that the government is taking a much, much harder stance. Finally, trying to make forest crime the high-risk, low-reward business it should be. But, it's not all about chasing criminals with chainsaws. Some of the biggest, most complicated conflicts happen when these modern official rulebooks slam right into a much, much older set of unwritten rules. We're talking about the customary rights of Malaysia's indigenous peoples. Now listen to this. This is a direct quote from Malaysia's highest court, and it is an absolute bombshell. The court said that the Orang Asli, the indigenous people, hold a proprietary right to their ancestral lands. Let that sink in. The courts have said this again and again. This isn't some privilege the government hands out. No, it's an inherent right. It was there first. And right here, this is the conflict in a nutshell. You have two rule books that are in a head-on collision. On one hand, you've got the state law, the National Forestry Act. Under that law, if you're an indigenous person foraging in a forest reserve, you're committing a crime. But on the other hand, you have the common law, the one from the courts, which says that same community has a pre-existing legal right to that very land. So think about that. The same action is both a fundamental right and a crime at the exact same time. It's a legal paradox. And as you can imagine, this legal mess, it leads to constant struggle on the ground. We're talking about communities setting up physical blockades, filing lawsuits, doing whatever they can to defend their ancestral homes from logging companies. And here's the kicker. Those logging companies often have what looks like a perfectly legal license issued by the state. Okay, so just when you think it couldn't get more complicated, a new, very powerful player enters the game. And this one operates from thousands of miles away. We're talking about international market demands, which are now basically acting as a brand new external rulemaker, forcing change from the outside in. Let me introduce you to the EUDR. That's the European Union Deforestation Regulation. Starting in 2025, it's going to ban products like timber and palm oil from the EU market if they're linked to deforestation. Simple enough, right? But wait, there's a second absolutely crucial test. Those products are also banned if they were produced in violation of the source country's own laws, and that explicitly includes human rights law. So, if you're a company and you want to sell your products in Europe, you now have to do 3 things. 1, you have to provide the exact GPS coordinates of where your stuff came from. 2, you have to prove that land wasn't deforested. And 3, and this is the revolutionary part, you have to prove you complied with all the local laws, not just the state license, all of them. And that includes those common law rights of indigenous peoples we were just talking about. So the big takeaway here is massive. When it comes to international trade, just having a logging license from the state, well, that's not going to cut it anymore. It's just not enough. What the EUDR has done, effectively, is it has turned these long-simmering domestic land disputes into a major international trade barrier. Suddenly, an unresolved conflict with an indigenous community isn't just a local problem for a state government to deal with. No, now it's a huge red flag that can get your products blocked from one of the biggest markets in the world. And that brings us right back to our big question, but now it's got so many more layers, right? When a single patch of forest is a source of cash for a government, an ancestral home for a community, and a global commodity for the international market, all at the very same time, who actually gets to write the final rule?